All right. The subject that we are going to discuss today is criminal law, the revised penal code, book 1. Okay. There are many students who are enrolled, around 3 sections in this subject. Now, there are some who are not able to submit their assignment, the module that I have given. So I advise those who have not submitted their assignment, please go to the dean's office and obtain a copy of the module for you to answer it and submit it, because that is one of the basis of my giving and evaluating your grades for this semester. This is the problem with the pandemic today. That's why I gave it a module for you to make your research. And it is better because if you are really a diligent student, you make your research, you read the book, and you answer the questions, you read the book twice, diba? Rather than listening to my lecture, whether you can follow it up. If you do not have the subject, the book on you, could hardly follow up the lectures. Now, because this is one of the requirements, that I'll give you a supplemental lecture on the revised penal code book 1. So, there are many of you who are enrolled in this. Now, revised penal code book 1 is a basic for criminology students. And these are the basic principles on criminal law. So, remember here that the revised penal code was created by Republic Act, okay? And this is created by the Republic Act, which took effect in 1932, January 1, 1932. Try to look into it that this law that was created by Act number 3815, there are some what we call the few amendments on it. Okay, so Act number 3815 that created the revised penal code, it took effect on January 1, 1932. There are some what we call the amendments that were legislated by the Congress. Okay. Now, what is criminal law? Criminal law is a branch or division of law which defines crime, threats of their nature, and provide for their punishment. If you try to see the definition of criminal law, it defines the crime. That's why if you try to go to book 2, the several crimes that are being put there are being specifically defined by law, and how you treat them, the nature of the crime, and the penalty that is provided by law. So that is what we are talking of the criminal law, which is a branch of which define the crimes. Now, what is the basis? This is the police power. The police power. Now, these police power are being sometimes what we call the power for the state to legislate. But there are limitations, and these are limitations, we call it the ex post facto law and the bill of attainder. Now, when we are talking of the ex post facto law, what is this ex post facto law? These are the things that would limit the power of the state to legislate criminal law on the revised penal code. Now, if we try to go to the history of the revised penal code in Philippines, you have to remember the Code of Calanchao, the Spanish Código Penal, and the revised penal code that took effect on 1930. Most of the provisions of our criminal law are lifted from the what we call the Spanish Código Penal. That's why sometimes you find it that many of the terms are Spanish words, because most of our revised penal code provisions are lifted from the Spanish Código Penal. Now, let us try to go to review some terminologies. Law. What is law? It is a rule of conduct, just and obligatory, promulgated by competent authority for the common good and observance and benefit. So, law is what we call the rule of conduct, which are legislated, okay, and promulgated by, well, the Congress or competent authority. When we are talking of crime, these are act or omission punishable by law in its act omitted or committed in violations of the public law, forbidding or commanding it. Crime. Felony is an act or omission in violation of the revised penal code. Offense is an act or omission in violation of special law. Try to see. Crime, felony, offense are sometimes interchanged. But if you try to go to the legal meaning, felony refers to the crimes punishable by the revised penal code. Offenses are acts or omission which are punishable by special law. Okay? But sometimes you interchange offense or crime, but for legal purposes, that is the real meaning of it. Now, what is omission? Omission means inaction, failure to do a positive duty which one is bound to do. Because if you try to go, even if you omit, you fail to perform an act, you are still liable. There are offenses that would punish people who fail to render or to perform an act. Because when we say crime is an act or omission, you perform an act or you fail to perform an act, and you committed a crime. Now, what is an act? Means it is a bodily movement. It's a bodily movement tending to produce some effect in an external world. When you perform an act and it produces what we call an effect, then yes. But if you are performing an act and there is no effect, then you cannot evaluate whether that act is criminal or not. Let's go to what we call the philosophies underlying the criminal law system. In other words, what are the philosophies? Okay. One is the classical or juristic theory. Classical or juristic theory. Now, you can remember this classical or juristic theory in a maxim that we call it an eye for an eye, a tooth for a tooth. The purpose of the penalty in this philosophy is retribution. The offender is made to suffer for the wrong he has done. So, in the theory of classical is, you punish the person for what he has done. An eye for an eye, tooth for a tooth. And this is one thing, the basis of the imposition of the death penalty, an eye for an eye. Okay. Now, a man is regarded as moral creature who understands what is right from wrong. And he must be prepared to accept the punishment. Because a man is a moral creature, he knows what is right and what is wrong. And he should be ready of the act that he should make. Now, the second theory is positive or the realistic theory. The purpose of the penalty in this philosophy in criminal law system is reformation. And this is the purpose of the probation law. do not punish you. The punishment that you give is for them, for that accused or for that person to reform, which what we call a social constraint a person to do a wrong, although not his own volition. The tendency towards crime is the product of one's environment. There is no such thing that man is a natural born killer. So sometimes a person commits a crime because he's influenced by the nature or by the environment. Okay? By environment. Sometimes they are pushed to commit a crime because of the environment that he is within. Now the third is the eclectic or mixed theory. Okay. The mixed theory is the combination of the classical and the positive. These combine both positive and classical thinking. Crimes that are economic and social in nature should be dealt with a positive manner. So in other words, if the crime involves economic in nature, then they should be treated with a positive penalty. Positive penalty. Because these are economic in nature. Thus the law is more compassionate and heinous crimes should be dealt with classical manner. Thus the capital punishment, the revised penal code, should follow the mix or the what we call the positive and classical. It depends. Even if he committed a crime, he can be reformed because we have said man is not a natural born killer. These are the basic theories of the philosophies on the imposition of penalties under the revised penal code. I would like you to remember some of the maxims in criminal law. Okay. Like the doctrine of pro reo. What is pro reo? Whenever a penal law is to be construed or applied and the law admits two interpretations, one lenient to the offender and one strict to the offender, the latter interpretation which is lenient and favorable to the offender. In other words, if the evidence presented by the defense and the prosecutions are equally balanced, you give favor to the offender. You give favor to the offender. Because their evidence, the prosecution and the defense are equally balanced, the same. So the weight of it then favor the accused under the doctrine of what we call the pro reo. Nullum crimen nulla poena sine legis. This is what we call that there is no crime when there is no law punishing the same. Yes. If there is no law that would punish an act, you are not criminally liable. Like, is there a law that would punish peeping Tom? Wala. Are you liable of peeping Tom? No. Because there is no law that would punish that. So even if you commit an act which is wrong, if there is no law that would punish, you are not liable under this. There is no crime when there is no law punishing it. Now, we go to what we call the actus non facit reum, nisi mens sit rea. We call this, the act cannot be a criminal where the mind is not criminal. Oh yes, the act cannot be criminal where the mind is not criminal. If your mind is not a criminal, you cannot commit a criminal act, diba? So this is what we call because in the commission of a crime, they are what we call intentional. They are characterized by dolo. Okay? And sometimes you go also with the culpa of negligence, but these are also with the basic characteristic of freedom. But only because lack of skill, then you are able to commit that crime. We will discuss that when we go to that. Okay. Actus me invito est meius actus. An act done by me against my will is not my act. Oh yes. If this is where we go to what we call the insuperable cause, you perform that act, but that is not your will. Okay? That is not your act. You are forced to do it. You are forced to do it. Okay? Remember the death penalty. Okay. You are the one who will switch. Patay yung tao. Okay? You are what we call, that is not your act. That is against your will. But you have to do it because that is your function. So your mind is not criminal. Okay? Now, we go to dura lex sed lex. Well, the law is harsh, but it is the law. Now, when we are talking of sources of criminal law, the sources of criminal law is, well, I have said the Act number 3815, the revised penal code. And what are others? Acts of the Philippine legislatures, the Congress, acts of the Congress that legislate the special laws. The special laws. These are acts of the Congress. Now, we have presidential decrees. There is still PD, presidential decrees issued by President Marcos before, which are still valid today. We have executive orders. What are latest executive orders? You remember the executive orders issued by the President today on the pandemic? Like you are still liable, curfew hours, violations of the protocol. These are executive orders that attaches penalties. And these are what we call the sources of criminal law. Now, when we are talking of the characteristics, what are the characteristics of criminal law? One, generality. When we are talking of generality, the law is binding upon all persons who reside or sojourn in the Philippines, irrespective of age, sex, color, creed, personal circumstances. So, irrespective of who you are, as long as you stay or sojourn in the Philippines, you are subject under the criminal law. The second characteristic is territoriality. When we are talking of territoriality, the law is applicable to all crimes committed within the limits of the Philippine territory. So when we are talking of Philippine territory, you look back to your constitution, what we call the archipelagic doctrine. The archipelago that define the territory of the Philippine Republic. By the way, you do not have any constitution in the college, yes? They remove this subject and they put it to the K-12. You know, wala na kayong Philippine Constitution in college because you took it in first year college, but now today, under the new curriculum they put it in the K-12. Those people who made those, what we call your subject here, are ignorant of the reality. Why do you remove the Constitution in the College of Criminal? That's a basic for police to know. The Constitution. Diba? And that is the basic of the law. Kaya nga minsan yung mga nasa taas na mga decks yan, these are people who are sitting in the swivel chair. They do not know what is reality on the field. Diba? Why remove? Okay. And that's supposed to be an important subject in college. What does a grade 7 or grade 8 do understand? Okay? Now, we go to the third characteristic, or yes, we call it the prospective or retrospective. The law does not have any retroactive effect except if it favors the accused, who is not a habitual. So, this is where I'm talking like in the doctrine of the pro reo. that the criminal law does not retroact back because it goes forward, prospective. But if the law is beneficial to the accused, then the law can be applied. Okay? So remember here, you can go into irretrospectivity of the law if it benefits the accused. But if it does not, then it must be prospective, forward. Okay. Now, remember the principle of the French rule and the English rule. We follow the English rule in the Philippines, okay? Meaning that such crimes are triable in that country unless they merely affect things within the vessel or refer to the internal management thereof. And in the French rule, the rule suggests that such crimes are not triable in the court of that country unless they are commission or affect the peace and security of the safety or in danger. But not so much, but at least you saw what is French rule and English rule. All right. This is what I'm talking of, the basic principles of Book 1. Now, I've said an ex post facto law, the law that would make a previous act criminal although it was not at the time it was committed. Ex post facto law. Okay, at the time when he committed the crime, there is no law that would punish. But later on, there is a law now that is passed by the Congress. Would it affect what you have committed before? No. That is a violation of the ex post facto law. Okay. Now, Bill of Attainder is a legislative act that inflict punish without trial. Well, this is what we call a basic violation of the due process of law. Bill of Attainder. You are being punished without trial. And these are what we call the limitations. The limitations of the police power. Now, let us now go into what we call the article, okay, of the revised penal. Article 1 is the date when the law took effect. I have said January 1, 1932. Okay. Now, Article 2, territorial applications of criminal law. Now, this Article 2 is what we call an exception to the principle on the characteristic of territoriality. Because I've said, territoriality, the law is applicable to all crimes committed within the Philippine jurisdiction. But Article 2, these are crimes committed outside the Philippine territory and you are still liable. There are many questions in the board exams on this, Article 2 of the revised penal law. What are these crimes that even if you commit outside the Philippine territory, you are still liable? 1. Should commit an offense while in a Philippine ship or airship. So, this ship is parked outside or outside the Philippine territory and you committed a crime inside the ship, are you liable? It depends. If that ship is a commercial ship, then you have to look into whether that commercial ship is registered under the Philippine law. If it is registered under the Philippine law, then apply the English rule. Okay? Second, if that Philippine ship is owned by the armed forces of the Philippines, yes, whether whatever place it was parked outside the Philippines, you are still liable because that airship or that Philippine ship owned by the armed forces of the Philippines is an extension of the Philippine territory under international law. Okay? So, that is. So, when you're talking of that, you have to see whether it is owned by the armed forces. If it is owned by the armed forces of the Philippines, automatic. It is an extension of the Philippine territory. Second, should forge or counterfeit any coin, currency, note of Philippines or obligation, and securities issued by the government of the Philippines. When you forge or counterfeit a Philippine coin or Philippine currency, even outside the Philippine territory, let's say you're in Japan, and you counterfeit and you are caught in Japan, are you liable in the Philippines? Yes. Can you be tried in the Philippines? Yes. Now, third is, should be liable to acts connected with the introduction into the Philippines of the obligation securities. Example here, you forge the Philippine currency in Japan. You are now coming to the Philippines to introduce, and you pass by Thailand. And in Thailand, you are caught in Thailand. Are you liable? Yes. Can you be tried in the Philippines? Yes. That is paragraph 3. Paragraph 4. When being a public officer or employee should commit an offense in the exercise of his functions. Remember that ambassador who is left his kasambahay, who is an ambassador outside, I think, in Saudi Arabia. Yung she maltreated the kasambahay. He's now being tried in the Philippine territory. So a public officer who commit a crime outside the Philippines in relation to his function can be tried in the Philippines. Ambassadors. If an ambassador commit a crime inside the embassy of the Philippine embassy, the Philippine embassy is an extension of the Philippine territory. An ambassador who raped somebody in an hotel outside, let's say in Japan, is he triable in the Philippines? Yes, in relation to his function. Have you, nakakalimutan ko yung pangalan yung babae na yun na ambassador na minaltreat yung sa TV. Minamaltreat yung katulong. Yung katulong taga Cotabato. He's now being tried in the Philippines, and the president have ordered that he should be immediately be suspended. Ewan ko kung naalis na. The fifth is, should commit any of the crimes against national security or the law of the nation. Go to Book 2, Article 114, Crimes Against National Security. Okay? If this you commit even outside the Philippine territory, you are still liable. Article 114, 115, up to 1119. Violations on the national security of the state. Book 2. Now, well, we are now having a new law that even if you commit outside the Philippines, you're still liable. Remember this Republic Act 9372, the Human Security Act of 2007. Okay. The Human Security. Now, we are having another law on Terrorism Act. Okay. These are, even if you commit outside, you are still liable. Now, we go to Article 3, felonies. We have said that felonies, these are acts or omissions that are committed in violations of the revised penal code. Okay? Now, the elements here, the omission is a punishable under revised penal committed either by dolo or culpa. When we are talking of dolo, these are intentional acts. So there is intelligence, there is freedom, and there is criminal intent of the offender. When we are talking of culpa, there is also intelligence, there is also freedom. But the act is imprudent, negligent, or lack of foresight, or lack of skill. Okay. So, because of his lack of skill, lack of foresight, he committed an offense, a felony. So, we call that culpa, an intentional act. Okay. We go to the crimes on mala in se and crimes on mala prohibita. When we are talking of crimes mala in se, this is what we call, these are violations of the revised penal code. When we are talking of mala prohibita, these are violations under special laws. Okay? Special laws. They are wrong in itself because there is a law under a special law. Now, under the revised penal code, these are what we call, these are wrong from its nature. These are wrong from its nature. So these are what we call mala in se. Now we go to Article 4. Criminal liability shall be incurred by a person by committing a felony and by performing an act which would be an offense against persons or property. Okay? So, that is Article 4. Article 5 is, well, these are duties of the Congress to legislate. But what is more important is the stages in the commission of felonies. What are the stages in the commission of the felony? We have the consummated felony, we have the frustrated felony, and we have the attempted felony. When can you say that the crime is consummated? A felony is consummated when all the elements necessary its execution and accomplishment are performed. When the act, all the elements provided by law are all performed, then we call it consummated. When we are talking of frustrated, a felony is frustrated when the offender performs all the acts of execution which would produce a felony as a consequence, but nevertheless, we do not produce it by reason of cause independent of the will of the perpetrator. I give you an example here. A stabbed B. Now, B was brought to the hospital and B was treated and he survived. What's the crime committed? Frustrated. Because B survived by an independent, not from the perpetrator. Okay? So that is what we call the crime. It did not produce the crime because of an independent of the will. Okay? The reason cause independent of the will of the perpetrator. Frustrated. By reason of other cause that the crime is not what we call consummated. When we are talking of attempted, this is what we call there is an attempt when the offender comments of the crime directly by overt acts and does not perform all the acts of execution which would produce a felony by reason of some cause or accident other than his own spontaneous desistance. Well, this is what we call an attempted stage. You remember, if you go to the law on the crime, there are what we call the requisites. If all the requisites in the performance of the crime is not all performed, then yes, it is an attempted stage. Okay. So, we go to what we call Article 7, and in Article 7, we call this the felonies. Light felonies are the infractions of law for the commission of which the penalty of arresto menor, or a fine of not less than, fine exceeding 40,000 pesos. Previously it is 200, now it is amended by a Republic Act that increased the penalty. So, light offenses, you can consider that crime to be a light offense if the penalty imposed by law is arresto menor. We will discuss the duration of those crimes in the last. Okay. Now, Article 8 is what we call the conspiracy and proposal to commit a felony. Now, conspiracy and proposal to commit a rebellion, treason, and sedition. This is what I am talking a while ago on the crimes against the law of the nation. Okay? Rebellion, treason, sedition. Now, you can be liable under this on conspiracy and proposal when you propose to commit rebellion. Conspiracy and proposal to commit a felony is a manner of incurring criminal liability. But what is conspiracy? Conspiracy exists when there are two or more persons come to an agreement concerning the commission of a felony and decide to commit it. In other words, when there are two or more persons come to an agreement to commit a crime, and they are decided to commit a crime, then there is conspiracy. That's why when you go to the information filed by the prosecution, they say that A, B, and C aided, helped one another. That is conspiracy, helping and aiding one another in the commission of the crime. That is what you call conspiracy. What's important here? Because in the law and evidence, in a conspiracy, when a conspirator admits, then the other conspirators are also liable. Because there is what we call an agreement between all the parties. Conspiracy. Now, classifications of felonies as to its gravity. Okay, that is in Article 7. So, we can say that a crime is a light felony when the penalty imposed by law is arresto menor. We can say that a crime is less grave felony those which the penalties in their maximum on prison correctional. Thank you. Prison correctional. If the penalty imposed by law is prison correctional, then we call that less grave felony. But when the penalty imposed by law is what we call the penalty imposed is capital punishment, we call that grave felonies. So heinous crimes are considered grave felonies. So in the classifications of what we call as to the gravity of an offense, you have to look into the penalty imposed by law, so that you can consider it as a grave offense or a light offense or a less grave offense. Okay. Now we go to the basic ones, Article 11, 12, 13, 14, and 15. These are circumstances that affect the criminal liability. When do I say affect or it modify? It would, what we call, increase the penalty, or it would increase the penalty, decrease the penalty. So it would aggravate, or it would, what we call, modify. So let us try to see Article 11, justifying circumstances. You know, these are circumstances that would affect criminal liability. I put it JEMAA. JEMAA. Justifying circumstances, exempting circumstances, mitigating circumstances, aggravating circumstances, alternative circumstances. Okay? So, Article 11, we are talking of the justifying circumstances. What are these circumstances that would justify an accused in the commission of a crime, and he is not liable? One, self-defense. Paragraph 1 is self-defense. However, you are not criminally liable if you prove the requisites of the self-defense. And what are these? 1, there is an unlawful aggression. Second, reasonable necessity of the means employed in order to prevent or repel. The means you have used to repel the aggression is reasonable. Okay? And the third is lack of provocation on the part of the person defending himself. If you have the 3 requisites, then your self-defense, then you are not liable. Okay. But remember, in criminal procedure, when you invoke self-defense as your defense, then it is your burden to prove the requisites. It is your burden to prove the requisites. And if you fail to prove all the requisites, you are criminally liable because you admitted. Kaya minsan yung mga tao, oh, self-defense yan. Self-defense, but are the requisites complete? Okay. Now, these are what we call self-defense. Now, the self-defense includes offenses on property rights. Property rights, inaagaw yung property mo, binuntalan mo, di ba? Because you are defending your property. So it is not only it affect on crimes against person, even crimes against property. Okay? Like yung inaagaw yung cellphone mo, sinuntok mo, di ba? You are defending your cellphone. Di ba? That's the property. Are you liable kung naalis yung 3 ngipin? No. That is what we call defense of a property. Property rights. Well, there is one on Republic Act 9262, Anti-Violence Against Women. If a battered woman syndrome shall incur no criminal liability. Yung battered woman, diba? Sinusuntok yung asawang lalaki at inistab patay yung asawa. These are self-defense battered syndromes. Okay. Now, we go to the second paragraph, defense of a relative. Okay. So the same requisites. In a defense of a relative, who are relative? Spouse, ascendants or descendants, legitimate, natural, or adopted brother or sister, relatives by affinity within the same degree, and relatives by consanguinity within the 4th civil degree. When we are talking of relative by affinities, by marriage. When we are talking of relative by consanguinity, by blood. So your first cousin is your relative by consanguinity on the 4th degree. On the 4th degree. If only we have some blackboard, I can draw you how you count the degrees going to the relations. But your first cousin is your 4th degree relations. Okay? Now we have also to prove the requisites: unlawful aggression, reasonable necessity of the means employed, and the person defending be not induced by revenge. So the relative that defends a relative should not be induced by revenge or what we call resentment or evil motive. Hindi na, ngayon na lang pagkakataon ko, evil motive. Okay? Third, defense of a stranger. Okay. And who is a stranger? He is not your relative. Okay. The same requisites: unlawful aggression, reasonable necessity, and the person defending him, the stranger, must not be induced by evil motive, resentment, or revenge. Fourth paragraph, the state of necessity or avoidance of an evil injury. You avoid an evil injury. The evil sought to be avoided is actually exists. The injury referred is greater than the done to avoid it. Then there be no other practical less harmful means of preventing it. Then, you are not criminal, but you are civilly liable. All right, you are driving, and you are fast, but there are people who are crossing, and you swerve, and you bump a tricycle. Because you swerve to avoid that greater. You avoid to bump those people, which is a greater evil than the tricycle part. Okay? Are you liable for that damage? Criminally, no. But are you civilly liable? Oh, yes. Civilly liable. Because you are avoiding a greater evil. Paragraph 5. Fulfillment of a duty or lawful exercise of a right of an office. The accused acted in the performance of a duty or a lawful exercise of a right of office. The injury cause of the offense committed is necessary consequences of the due performance of duty or lawful exercise. This is what we call the doctrine of self-help. Okay? The doctrine. You are a public officer and you perform your duty in accordance with your function, but it resulted to some offense. Okay? Are you liable? No. Because you are performing a duty. Ito, you are police. You're going to arrest that person. And you said, I'm a police officer, you're making trouble, I'm going to arrest you. And you're going to put him in a mobile car, but he tried to fight back. But you lifted and put him in the mobile car and naiuntog. Are you liable? Not physical. No. You're performing a duty. Ayaw nang pumasok eh. Lasing eh. Lalo na kung tagahin yun. Ay, may tagahin yun ba dito? Ay, walang ipugaw. Kung walang taga-ipugaw dito, you do not understand what I'm talking all about. Yung mga pugaw, ina-arrestar mo, lumalaban. You force it. You're performing a lawful duty. Okay? Now, paragraph 6. Ito, obedience to an order issued by lawful purpose. Oh, yes. Ito, shoot to kill. Shoot to kill. Ito yung order ni President sa mga drug war, di ba? Pag naglaban, patayin mo. Kaya nga, lahat ng pinatay mga pulis sa drug war, nanlaban. Nanlaban, di ba? So that they will be justified on paragraph 6. Pero you try to see what is the gun. That is the gun that was used in Quezon City, the same gun that was used in Caloocan, di ba? Pare-parehas yung baril. Pero maganda. Maganda yan. And that's the duty of the President to remove drugs. But we will discuss that when we go to the other subject who are enrolled on human rights. I will discuss that on the human rights. Is that human or that is inhuman? And that is what I'm talking on, a lawful order. Okay. So these are the justifying circumstances. Remember, there are 6 paragraphs. We go to Article 12, we have the exempting circumstance. Exempting is, you are exempted from the criminal liability. In paragraph 11, Article 11 is, you are justified in the commission of the crime. Okay? That's why you are not liable, because you are justified. Here in Article 12, you are exempted. Paragraph 1. Okay? Imbecility or insanity. Well, what is insanity? Not a permanent, these are what we call a defect in the brain. But when we are talking of insanity, you are not criminally liable when at the time you committed the crime, you are insane. But remember the lucid interval. You know, the lucid interval sometimes you're crazy, sometimes you're good. That's why they say in the Ilocano, if the moon is round, you are crazy. If the moon is half, you are good. Lucid interval. But if you committed a crime under your lucid interval, you are still criminally liable. Okay? Insanity. Imbecility. When we are talking of imbecility, this refers to old age. Yung mga nagkakabaw, imbecility. This is what we call feeble-mindedness, somnambulism. Crime is committed with the suffering of, malignant malaria that he does not anymore control. Kleptomaniac. Okay? Somnambulism. What is somnambulism? Yung natutulog, naglalakad, di ba? Hindi niya alam. Somnambulism yan, di ba? May nakikita kayo? Meron. Ha? Natutulog, naglalakad, ewan kung saan pumupunta. Second paragraph. We call that minority. Minority as amended by RA 9344. Okay. When we are talking of the RA 9344, well, I can still consider this as a stupid law created by the Congress. What is this law? Minor children 15 years and below are not criminally liable. Diba? My God. I went to a shooting range in Baguio City. I have seen a 12-year-old magaling bumaril. Tinatalo pa yung mga colonel. Batang-bata. Anak ng doktor. Tumatakbo sa firing range. 12 years old. So if he shoots you because he's below 15-year-old, he's not criminally liable under RA. Ito yung mga stupid ng mga congressman ninyo. Pwede noon in the 1940s or 1950s, di ba? Pero bakit legislate? Because yung mga anak ng congressman, they are the troublemaker, di ba? Except sa Ifugao noon, because Bagilat has no son. Walang asawa. But you see, now the other one is 15 years old, but less than 18 years old, is not criminally liable unless he committed with discernment. And what is discernment? Discernment if that person knows what is right and what is wrong. If he knows what is right and he knows what is wrong, then yes, he is liable. Now, who determines discernment under the law? Social worker. Anong alam ng social worker sa psychology? Stupido. Dapat psychiatrist, di ba? Ang alam lang ng DSWD is ayuda. Yan lang alam nila. The most abused today. Di ba? Yung ayuda. Yan lang. But what do they know about the discernment whether that child knows what is right and what is wrong? And one of the famous case there is, yung isang bata, binaril yung kasambahay. Involving a TV. Because the child would like to watch a channel, but yung kasambahay change the channel. Anong pinalit? Yung wawawi yata. Pumunta yung bata sa kwarto, kinuha yung baril ng tatay, binaril. After na binaril yung kasambahay, linagay, pinalit yung channel, nanonood. So, he does not know if it is right or wrong. That's one of the cases in the Supreme Court. Okay. So, paragraph 4, accident. When we are talking of accident is, the crime committed is what we call accidental. Okay. He's performing a lawful act. But he performed with due care. But despite of performing a lawful act with due care, that injury or a crime was committed by an accident without fault or intention of causing it. Okay? Ito yung ang kaso yung dalawang boxer. Okay? In a lawful boxing fight, naglaban sila. Pero yung isa, sinuntok yung kalaban, he was overthrown on the ring, sa baba, naiuntog ang ulo, patay. That is an accident. Is the one who boxed him lawfully. That's an accident. He performed a lawful act because they are in an athletic boxing arena. Okay? With joke pero malakas sumuntok kaya nga. Ito yung mga kasong na it reached up to the Supreme Court just to say whether it is accident or not. Di ba? Maraming mga aksidente. Hoy, alis ka dyan, tinulak mo. Naialis, nahulog. Di ba? Accident. You're performing a lawful act. You just want to push him a little, but you do not have any intention. Now, paragraph 5 is irresistible force. The actor or the offender is reduced to a mere instrument or weapon because he acts not only without will, but also against his will. There must be physical force. Okay? Irresistible force. Okay, babarilin mo yan. Kung hindi, ikaw ang babarilin ko. Okay. Wala kang magawa. Uncontrollable fear. Moral force, intimidating or threat, a compulsion must be character that the actor has no opportunity to escape. The actor is reduced to a level of a weapon. Uncontrollable fear. 7. Prevented by insuperable cause. There must be lawful requiring the performance of an act. Okay? This is what we call omission. You are required by law to perform, but you fail, refuse to perform. You are liable. Prevented by insuperable cause. Like a person, you are walking, you have seen a person in danger of life, but you did not give assistance. Okay? You have just seen it and you left. It is your obligation to assist. He is in danger of life. But the law says you have to give an assistance of a person in danger of life without also danger of your life. But if it is danger your life, then you are not liable. Okay? Ito yung mga maraming mga pulis na hindi alam. Yung you are driving, you bump a person, di ba? Instead of giving aid, you escape. That is an aggravating circumstances. That would increase the penalty of reckless imprudence. Because you fail to render omission. That is paragraph 7. Okay. So it would not be an exempting, but it would be an aggravating because you fail omission. So these are what we call the exempting circumstances. Now, we go to what we call absolutory cause. Okay? And the mitigating. But I'm more interested on the incomplete justifying or exempting circumstances. And what are these? Paragraph 1, incomplete justifying circumstances. When all the requisites necessary to justify the act or exempt of criminal liability are not attended. Minority or old age. Okay. Minority is 18 and below. Old age is 70 years old and above. Okay. These are what we call the mitigating circumstances. That would, when we say mitigating, it would lower the penalty 1 degree or 2 degrees. It depends. Okay? So it would mitigate, reduce the penalty. Praeter intentionem. What is praeter intentionem is the offender had no intention to commit so grave a wrong. Okay. He has no intention to commit so grave a wrong, but it resulted. Like what we call the offenses that does not result to a physical injury. Example dito, pumunta yung tao sa inyo, sakit ang tiyan. O sige, inumin mo itong, parang maalis yung sakit tiyan mo. Ininom mo, it causes gastritis in your stomach. Are you liable? No, because you do not have any intention. Paragraph 4, provocation or threat. Well, the sufficient provocation or threat on the part of the offended party must be immediate, preceded an act. The threat must be amount to an unlawful aggression to the appreciation mitigating circumstances. Ito yung provocation. The one who made the provocation. Tingnan mo yung police, di ba? Yung akala mo bubunot, di ba? Binaril. Because he believed that there is a threat on his life. Inunahan. Kaya sabi ni Presidente, tanga kang pulis kung naunahan ka. Di ba? Ewan ko, yung mentality minsan yung Presidente natin, may topak-topak talaga. Pero maganda. Sabi niya, one time in the TV, tanga kang pulis kung ikaw ang naunahan. Dapat nauna ka. Mere provocation, a threat of your life. That he said that is self-defense. Paragraph 5 is vindication of a grave offense. Immediate vindication of a grave offense to the one committing the felony. Vindication. Okay. Example, tinuprahan yung mukha mo, sinuntok mo. Di ba? You vindicated yourself. Di ba? And these are what we call vindication. Grave allows interval, it does allow interval time. Now, paragraph 6 is passion or obfuscation. That of the having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. What is passion and obfuscation? Minsan nga, may mga taong sabihin, hindi ko nga alam kung anong ginawa ko. Parang he burst. Then he reacted. Because of that, what we call obfuscation. Passion. Yung passion, ito yung you have entered your house and you saw your wife with another man. Di ba? And you shoot them because of your emotion. We call that passion. You cannot anymore control. So you are given that mitigating. Voluntary surrender or confession of guilt. Oh yes. When you voluntarily surrender, these are mitigating. Or in a plea, during the arraignment you said guilty. That's mitigating. Okay. Voluntary surrender or confession of guilt. Voluntary plea of guilty. Now, physical defect. Physical defect of the accused must restrict by means of action, defense, or committing with his fellow beings. Okay. Physical defect on deaf and dumb has no relation on crime committed on physical. Okay. Hindi naman kailangan na you are dumb. Di ba? But physical defects can be what we call mitigating as long as the one that have committed an offense has no other, like he cannot anymore run, pilay siya, di ba? So, he committed but usually this goes to what we call the defense. But it can go also on a physical defect. Paragraph 9, illness of the offender. Illness of the accused must only admit his willpower. If it deprives him of the consciousness of his act, then it is an exempting. Well, illness. There are some what we call, there are some people that if you now ask, why did you commit that? I cannot. I lost my mind. So they cannot even remember. Illness. Similar and analogous circumstances. What are these similar? We have what we call the voluntary surrender of the stolen. Well, you return back what you have stolen. When the accused is over 60 years old, with a failing eyesight, poverty in relation to theft. Ito yung kaso, yung theft. Bata. Wala pa yung 15 years and below. Itong bata was too hungry. Was too hungry. He entered in a bakery and he get the bread and he eat it. He was charged for theft. But it went there. He was given that privilege because he is under the circumstances of gutom. Diba? So he was forced to commit that crime because of environment, force. And I have said to you, a person commit a crime because of environment or influences. Because he saw hungry, he committed that crime. But the Supreme Court said, he's given mitigating circumstances. But wala noon yung RA na 15 years and below. Wala yon noon. Okay? So that is what we called some analogous. Now, we have in an aggravating circumstances, we call that generic. Aggravating circumstances may be offset by ordinary. We have the qualifying aggravating cannot be offset by an ordinary mitigating. When you go to the mitigating, let's say one aggravating circumstances which is generic, one mitigating circumstances quits. Diba? You go what we call in the minimum, not the maximum, minimum, medium. Okay? So go on the minimum. If there is one mitigating, go one lower to the minimum. Yan ang penalty impositions. Di ba? Kaya nang binabalance ng aggravating, mitigating, exempting. So, and that is the purpose why you have to know what is aggravating because it aggravates the penalty. What is mitigating? It mitigates the penalty. One lower degree or 2 degrees lower. Okay. So, this is what we call some of the aggravating circumstances. What are these aggravating circumstances that would qualify as a qualifying aggravating circumstances? Advantage taken of a public position. Okay? Because of your public position, you take advantage. Another one is contempt or insult to a public authority. When you, in the performance of that public officer, you insulted him. Like usually in the barangay conciliation, there are some parties that insult the barangay, di ba? Can that be an aggravating? Yes. Because that barangay official is in the performance of reconciliations, but he's being insulted. Ano nga alam mo? But barangay kapitan ka lang na wala kang alam. Diba? You're insulting a public officer. Like in Ifugao when they say, pulpulit kalain. Diba? A police officer is trying to arrest somebody and is that person from Kiangan said, pulpulis ka lang. You're insulting a public officer. And that can be what we call a qualifying aggravating circumstances. Another one, disregard of rank, age, sex, dwelling. Yes, of course. When you disregard, let's say 30 years old versus 70 years old. If the 30 years old is the one committing a crime against that 70 years old, aggravating because of the age. Sex, male and female. Male have an advantage over a female. Okay. Dwelling. You perform a criminal act inside the dwelling of the offended. Okay. Paragraph 4, abuse or confidence on abuse. What we call the ungratefulness. Okay. Abuse of confidence. Paragraph 5 is palace of a chief executive or where the public authorities are engaged in the discharge of their office. Well, when a public officer in his public office is performing a functions and you disregard, okay, then it can be an aggravating. Now, what is common here is the nighttime uninhabited place. Nighttime is nocturnity. You adopted the nighttime to commit a crime so that you cannot be identified. Okay? That is what we call nighttime, nocturnity. Uninhabited place. You committed a crime in an uninhabited place so that there are no witnesses. Ban. When we say ban, this is what we call more than 3 armed men committed a crime. We call that armed ban. So they committed a crime by a ban. Okay. So this is what I'm talking of: nighttime, uninhabited place, and by a ban. The accused committed a crime during the nighttime to take advantage of the darkness so that he could not be hardly identified. What are others here? Well, yung mga ano ba ito? Mask. Using the mask now so that usually these are masks that used by robbers before, diba? So that they cannot be identified. These are. But today, well, is that already an aggravating that everybody should use a mask with a face shield? Paragraph 7, occasion of calamity or misfortune. Well, during calamity, natural or man-made calamity. Let's say in time of, during the typhoon, instead of helping you, made robbery. You made occasion on the advantage of that calamity. Okay? Either natural, I've said, or man-made calamities. And you committed a crime. You take advantage of it. These are aggravating. Aid of an armed man. Okay? Aid of an armed man. Okay, may kasama kang pulis. Oh, sinisingir mo yung kalaban mo. Sige, sabi ng pulis. Sige, nandito na ako. He's helping you. So you are emboldened to commit that crime. Aid of an armed man. Anong nangyari? Pakito na lang. Wala na yata. Tingnan mo nga. Okay. The other one, paragraph 9, is recidivism. When we are talking of recidivism, these are what we call recidivists, that would one who at the time of his trial for one crime shall have been previously convicted by final judgment of another crime, embraced in the same title. So he was convicted and he committed and he is on trial, embraced on the same title. Okay. Now, what are reiteration? Reiteration is, in paragraph 10, is the offender has been previously punished for an offense to which the law attaches an equal greater penalty for 2 or more crimes to which attaches a lighter penalty. So these are what we call aggravating recidivist, reiteration, habitual delinquency, and quasi-recidivist. Okay. So who is a habitual? When an accused within a period of 10 years from the date of his release of last conviction of a crime of serious or less serious physical injuries, robbery, theft, estafa, falsification, is found guilty of any of the said crimes for the 3rd time. So you talk of habituality, okay, habitual delinquency when the crime is committed on physical injuries, robbery, theft, estafa, falsification. Within a period of 10 years, he convicted 3 times. Talagang he is a habitual. Walang ginagawa kung hindi yan. So, these are what we call the aggravating. Price or reward. Price or reward or promise. Okay, you kill that person and I'll give you a prize. Aggravating because you committed a crime by a price, reward or promise. Promise. Let's say you do that crime and I will promote you. That's a promise. Now, paragraph 12 is by means of inundation of fire. You committed a crime by means of fire. Gusto mong patayin yung tao, you burn the house by means of fire. Okay. Now, paragraph 13 is evident premeditation. When we are talking of evident premeditation is you have planned the time, the place where you will commit the crime to ensure the commission of the crime. That is evident premeditation. There is a plan by the offender. So he adopted time, place, in order to commit, in order to ensure the commission of the crime. Paragraph 14 is craft, fraud, or disguise. Craft is trickery. Diba? Trickery is traitor. He made tricks in order to commit that crime. Fraud, use of words, deceit. Okay. You deceive that person. And disguise. Oh, ito yung disguise. Sinasabi ko yung mga nagmamas. Diba? Yung nagmamas. Noon lang, yung nagmamas, mga robbers. Pero ngayon, lahat ng Pilipino ay robbers. May mas na ngayon. Diba? Including the president. So, these are what we call the disguise, use of device to conceal identity. Okay? Paragraph 15, superior strength or means to weaken the defense. Superior strength, 30 years old versus 70 years old, superior strength. Weaken the defense. When we're talking of weaken the defense, okay, you got what we call the sand and throw in his face so he cannot see you, then you start boxing him. So you weaken the defense before. Okay? Like yung mga iba, yung they throw the acid, di ba, on the face. So, you employ means to weaken the defense when you commit that crime. And these are aggravating circumstances. Treachery. So, I've said treachery, this is tricky, this is aleviosa. There is treachery when the offender commits any of the crime against a person employing means, methods, or forms in the execution thereof, which tend directly, especially to ensure the execution without risk to himself from the defense which the offended party might make. So there is what we call, you adopted that treachery in order that you afford yourself to ensure the commission without risk unto yourself. That is what we call treachery. Paragraph 17 is ignominy. Okay? Ignominy is the offended party subject to moral suffering. Ignominy. Moral suffering. You let him, what we call his conscience, moral. In ignominy. Now, unlawful entry. Oh yes. You committed a crime inside the house of somebody with an unlawful entry. You are not allowed to enter. Okay. No trespassing. Ngayon. Breaking walls. When you commit a crimes, you break the walls, you break the windows, you break the floor, the roof, in order to enter to commit that crime. Breaking the walls. Yung mga robbery or murder, homicide, you break the walls. When you break the walls or windows or roofing or floors to commit that crime, these are aggravating circumstances. The other one is aid of a minor by means of motor vehicle. Aid of minor. When we are talking of aid of minor, well, ito yung mga you use minor children. And these are usually made by drugs now, di ba? As carrier, yung mga bata. Now, another one is by means of motor vehicle. You use your motor vehicle to kill. Let's say you intentionally bump. Aggravating. The other one is cruelty. When we are talking of cruelty, this is what we call the deliberate augmentation of crime by another wrong. Adding pain to an injury, adding insult to an injury, cruelty. Like before you kill that person, you remove his ear, you remove his nose, so that he will be suffering first before you kill. That is cruelty, which is unnecessary in the crime. So you just want him to suffer cruelty. Now, we are talking of, so these are what we call the aggravating circumstances, okay? 21 circumstances, aggravating circumstances. Now we go to the alternative circumstances, or we call that the absolutory cause. And this is wherein alternative because they serve to either mitigate or aggravate the offense. Either they will increase or either they will mitigate. We call that the alternative or alternative circumstances. And what are these? Relationship. The other one, intoxication. The other one is degree of education. RID. R-I-D. Now, when you commit a crime in order to ensure by relationship, then yes, aggravating. But you do not know the relationship, you did not use the relationship in the means of committing the crime. But later on you find out that you are related with it. It would be a mitigating. Intoxication. You get intoxicating alcohol to embolden yourself to commit a crime. Then yes. Yung nag-inom ka ng San Miguel to embolden to murit, di ba? To embolden yourself to commit a crime. That is aggravating. But suppose you are drunk and you do not have any means, that you do not have any plan to commit, but you are drunk, then at the time you committed that crime. You said, lasing ako, hindi ko alam eh. That is mitigating. Because you did not took intoxication to commit a crime. But you were intoxicated at the time when you commit the crime. So it becomes a mitigating circumstances. Acts, what we call degree of education, instruction. Ito yung doktor. Because of his education, he committed abortion. He used his education to commit abortion. Di ba? To perform abortion. That is aggravating circumstances. But suppose ito yung mga gas, yung mga matanda, di ba? Ang sakit ang tiyan, ito, inumin mo itong tuba, parang maalis. Nag-abort. He does not know the effect, di ba? The degree of his education, he does not know the effect of that tuba. So that is mitigating. So alternative is either aggravate or mitigate. Okay. Now, we go to Article 16. Persons who are criminal liable. Who are persons who are criminal liable? 17, principal. And who are principals? We call it principal by direct participation, principal by inducement, principal by indispensable cooperation. Okay? So, principal by direct participation, he's the one who committed the crime. Principal by inducement, you induce somebody to commit a crime by price, by reward, by promise. You convince. Now, principal by indispensable cooperation. Well, because of your indispensable cooperation, an example here is, you have a motorcycle. Sabi niya, dalhin mo ako dyan. So, bakit? Papatayin ko yan. So, dinala mo. Then he killed somebody. You are a principal by indispensable because if you did not brought him there, he should not have committed the crime, di ba? Indispensable cooperation. Because of your cooperation, he committed the crime. But if you did not cooperate, he should not have committed the crime. Although you are not the one who committed the crime, but you are the one who brought him there. Indispensable cooperations. Paragraph 18, accomplice. Okay? These are what we call the degrees of participation. Who is an accomplice? A person who cooperates in the execution of an offense by previous or simultaneous act. Okay? He cooperated in the execution of the crime, or by simultaneous accomplice. Let's say, in a crime of robbery, okay, ikaw ang bantay dito sa first gate. You are an accomplice. Because the person entered and committed the crime, but you are there as a security of the first gate. Now, the third is accessory. Those having knowledge of a commission of a crime and without having participated therein, either by principal or accomplice, but take part subsequent in the commission of any of the following. He did not participate. He's not a principal by direct. He's not an accomplice. But he profited from the crime. Okay? He can be an accessory. Oh, alam mo na, ninakaw ito, binenta sa inyo. Kinuha mo. You take advantage kasi mura. But you know that that crime is committed. You know the crime, they committed the crime. But you profited from that crime by concealing or destroying the body. Pinatay yung anong sabi, itapon mo yan, parang hindi makita. Okay. Hindi ikaw ang gumawa, pero you destroy the evidence so that it will not be identified. Harboring, criminal. Tinatago mo yung criminal, parang hindi ma-arrest. Harboring. This, you are an accessory. Okay. Well, I'm talking of what we call profiting. Remember the PD 1612? We call the anti-fencing law. Okay? The anti-fencing law. That you profited from what we call subject of theft or subject of robbery. But the difference here in anti-fencing laws, you do not know that that is a fruit of a crime of robbery. But in an accessories, you know that they committed that crime. And you profit from it. Diba? Article 20, accessory exempt from criminal liability. This is what we call the absolutory cause. That even if you committed a crime, you are not liable under Article 20. But you only committed a crime against a spouse, ascendant, descendant, legitimate, natural, or adopted brother, sister, relative by affinity. So you have to see to it that you have relation. Okay. I'll give you an example here. And this is in relation to the crime of theft, robbery, and estafa. Okay. So, estafa, theft, these are what we call ito yung absolutory. Yung tatay mo, dinagay yung pantalon sa cabinet, kinuha mo yung pera. That's theft, di ba? But are you liable? No. Because you are what we call the ascendants, descendants. Okay. But it only limits to a certain crime of theft, estafa. Okay. Now, but you should have been, one qualifying is, you have been living under his support. Di ba? Spouse, parents, brother, even if you commit a crime against your brother, as long as you're living with your brother and you are being supported by your brother, then yes. Or sister. These are what we call the absolutory exempting. Article 20, penalties. Okay? RA 9346, an act prohibiting the imposition of death penalty. Okay. So, this law suspend the imposition of penalty. It did not remove because it's still within the revised penal code. Okay. But it only suspend. Ito yung RA during the time of President Gloria Macapagal when they have made this Republic Act. Now, what are the penalties imposed by law? We go to the capital punishment, death, but this is what we call suspended. What are afflictive penalties? Afflictive penalties are reclusion perpetua, reclusion temporal, and prison mayor. What are correctional penalties? Prison correctional, prison mayor, arresto mayor, suspension, and destierro. When we are talking of light penalties, arresto menor, public censure. These are what we call the penalties. Now, I would like to go on the duration so that you know what are the duration. When we are talking of duration of penalties on reclusion perpetua is 20 years and 1 day to 40 years. That is the duration of the penalty. Reclusion temporal is 12 years, 1 day to 20 years. When we are talking of prison mayor, 6 years, 1 day to 12 years. Prison correctional, 6 months and 1 day to 6 years. Arresto mayor, 1 month and 1 day to 6 months. Arresto menor, 1 day to 30 days. These are what we call the durations of the penalty. However, these durations of penalty are divided into 3: maximum, medium, and minimum. Okay? So if we try to see the penalty on arresto menor, how do they divide the 1 day to 30 days? The maximum is 21 days to 30 days. The medium is 1 day to 20 days. The minimum is 1 day to 10 days. Minimum. I was in prison with an arresto menor, medium, because of this COVID. 14 days quarantine. Diba? That is imprisonment. If you are swab positive, you will be put to quarantine for 14 days. That is arresto menor. You are not allowed to get out. You know, this quarantine, pinagperahan ng mga DOH at saka PhilHealth. Pera-pera lang yan. So, that is what we call the durations of the penalties. Okay. Now, effect, monetary, Article 48, complex crime. What is a complex crime? The penalty to be imposed shall be the penalty of the most serious crime, the same to be applied in a maximum. Okay, complex. These are what we call complex crime. If there are 2 or more crimes that are in a complex, you impose the highest penalty. Okay. Indeterminate sentence law. Now, I'll go to what we call the total extinction of crime. When does a crime is being extinguished? Okay? Extinguished. Extinctions of crime. 1, death of the convict. Kung patay na yung accused, can you imprison a dead one? So, dismiss ang kaso, di ba? Extinguish. Service of sentence. If you already served the sentence, the crime is extinguished. Another one, amnesty. But when we are talking of amnesty, this refers to an amnesty of a large. Amnesty is an act of sovereign power granting oblivion or general pardon for past offenses. Amnesty is given by the President, executive branch, who gave them. But it refers to what we call granting of what we call this is a sovereign power, granting oblivion or general pardon for a past offense committed by individual or more. Okay. In relation to pardon, pardon is also an act of grace proceeding from the power entrusted with the execution of the laws. Pardon is when you forgive. Okay? This is what we call the absolute pardon. Prescriptions of crime. prescriptions of penalty, marriage of the offended party. Marriage of the offended party only involved in crimes against chastity, di ba? Rape, acts of lasciviousness, these crimes against chastity. When you marry the offended, yes. Well, but the marriage here under that law must be valid in order that it will be considered as extinction of crime. Now, when we are talking of prescription of crime, when does the crime prescribe that you are not anymore criminally liable? And when are you going to determine the date of the prescription? At the time of the knowledge of the crime being committed. So when you know the crime that is being committed, at the time on the knowledge of the commission of the crime, you can start counting the prescription. So, if the crime is an afflictive penalty, it prescribed in 15 years. Okay? Afflictive, murder, 15 years. So from the date that you know the crime being committed, you count. After 15 years, the case is not filed, then it prescribed. Correctional penalties, 10 years. Arresto menor, 5 years. Libel, 1 year. The penalty of libel, if from the knowledge of the libel and it was not filed within 1 year, after 1 year, it prescribed. Oral defamation is slander by deed, 6 months. Light offenses, 2 months. Okay. Light offenses. If the penalty is 1 day to 30 days, if it is not filed within 2 months, it prescribed. So what is the technique here? Oral defamation and light offenses, 6 months, 2 months. Di ba? You file it to the Katarungan Pambarangay. You let it be delayed in the Katarungan Pambarangay. After 2 months, okay, pwede na i-file mo. Prescribe. Okay. So, these are what we call the prescription of crime. Okay. Now, Article 100 is, well, a person that is criminally liable is likewise civilly liable. That's the only provision on criminal law that I can memorize. Article 100. A person that is criminally liable is likewise civilly liable. And that is the basis in Rule 111 in the Rules on Criminal Procedure. Okay. So, and what is the purpose here of the liabilities? In the civil liabilities, restitution. Restitution is you repay, you reinstitute, you pay back. The other one is reparation of the damage. When you made a damage, you repair it. Like when you destroy that fence, you repair, put it back. Civil liability. Indemnification. Indemnification is pay the damages. How much did he suffer? Indemnification, actual, moral, di ba? Yung mga kinds of damages. Mental. The kinds of damages is mental. M, moral, exemplary, nominal, temporal, actual, and liquidation. Those are the kinds of damages. But the most that you are going to ask is the actual damages. Okay. Reparation, restitution. Can there be a restitution in the crime of rape? Can you repair it back to be virgin again? No, you cannot. So there is no what you call restitution in those crimes. So that is what I'm talking of Article 100. Okay. 11 o'clock. Now, you better ask to some of your classmates who are enrolled under the subject who have not yet accomplished with the requirements. Okay. Remember here, I have given you questions 1 to 45. This will be your final exams. Okay? And I have based it here. Well, if you really perform the assignment here, like you define criminal law, crime, yes. Pro reo, these are things. Now, what are light felonies? These are light felonies. These are the penalties is 1 day to 30 days. Yeah, if the penalty. Requisites of dolo, freedom, intelligence, intentional. These are so. The thing that I have given you here in my what we call my module, well, you accomplish it and submit it to the dean, and I will collect it from the dean's office, and I will evaluate as the basis of your grades, okay, plus your final exams. This will be your final exam, 1 to 45, okay. I will check it. All those who have passed it is still intact in my room, okay. So, I have noted those who passed. Kaya may isa, si Marian, sabi na, sir, may pinasok ko. Sabi ko, dito sa record ko, wala. You want that I will bring all the assignment? I have all the evidence. Ito lang ang mga assignment na na-collect ko. Wala kang pangalan. So, this. So, you better advise, itong pandemic, you should take advantage. Walang babagsak. Di ba? As long as you comply. Walang babagsak. Di ba sabi ng DEX? Walang ibabagsak. As long as you comply with the module that I required, you have a grade. But if you do not comply, anong ilagay ko? No grade. I will not put that you will be a member of the Iglesia ni Cristo, incomplete, because that is not, ang ilagay ko, no grade. Pero noon sa regular klase, if you do not pass the assignment, I put INC, Iglesia ni Cristo. So, ito, you better ask to you there are some from far away, far places, if you know them, you text them. Pwede naman na i-feed ninyo ito, di ba? Yung mga, so that yan, may nag-accomplish. Tumatawa ako dito sa final exams, yung mga nag-pass, okay, 28/45. It means hindi nagbabasa eh. I'm expecting, okay na. I'm expecting 45 questions.